you, Adam, for that, and welcome, good afternoon, good evening, good morning to everyone that's out there and joining the Bosco Conference. My pleasure to be here. As Adam has said, I am working for a multifamily office which were globally represented, called Stonehage Fleming. Not only do we have a family office in the sense of asset management, but generally a much wider range of services perhaps than some other such family offices might provide. So we look after families in their entirety and all their needs. We currently have somewhere in excess of 250 ultra high net worth families that we cater for their needs. My own particular role within that has developed over the years. I've been with the group now since 2006, so about 14 and a half years now. I started off being a compliance officer in London. I moved to Switzerland in 2009 to take over the compliance role there for our Swiss businesses, and have remained in Switzerland ever since. I'm currently, in fact, based in Zurich. During my time as a compliance officer, along came something called US FATCA, closely followed by UK FATCA, and lastly the OECD's Common Reporting Standard, the CRS. This had a major effect on our group because the requirements of the regulations were going to put an enormous burden on our business. So we launched a project to implement this globally in the various jurisdictions we operate. And for my sins, I was made the project manager for this, and we have implemented it. And as a result of having to do this, I was no longer the compliance officer, and my role in that aspect ended. Over the years that we've been doing this now, which really stretches back before 2014, I've developed a store of knowledge around these various rules. And such we, as a group, saw an opportunity to assist our clients and assist other businesses who are struggling with the regulations. And in fact, my role now is twofold. It's to make sure that our group remains compliant, in particular with CRS and FATCA, but also other aspects which I'll talk about later and which have developed since then. So beneficial ownership registers, substance rules, and the like. All of now which I'm responsible for, ultimately for ensuring that the group, as I say, remains compliant. The other side of my role is to provide consultancy services around these aspects, both to client families and, as I say, to other service providers such as fiduciaries. And this is what I wanted to talk to you about today. Previously, we've focused on automatic exchange of information, so FATCA and CRS. And really the focus there was more about advising clients what was being reported, about whom, why they were being reported, who they were being reported to, who was doing that reporting, and so on and so forth. Because with these client families, of course, the reporting that flows ends up at a tax office somewhere in the jurisdiction in which they live. And typically, that is triggering tax inquiries. So they needed to know who was being reported, why they were being reported, what was being reported, so that they were prepared and ready should a tax inquiry come along. I'll explain a bit more about the vagaries of the rules in a short space of time. But one thing is apparent is that people are being reported with alleged financial accounts which actually do not exist. And of course, this is not going to appear on their tax returns. No reason why it should. But these are generating inquiries from their home tax authority. I can give a number of examples, but in Switzerland, for example, I know with a protector of a trust, which is a Jersey resident trust, and it had assets to somewhere north of $300 million, that trust has to report a protector and basically say that this protector has a financial account, the value of which is $300 million. Now, strangely enough, that protector, who happens to be a Swiss lawyer, did not report that on their tax return as part of their wealth tax. Why should they? But latterly, it's become apparent that things are wider than that. I tend to refer to this now as the transparency agenda, and which is really the subject of my talk today. And it's about privacy, and it's about whether that privacy actually exists anymore, and hence the title of the presentation. So I will start by asking the question, is privacy dead? In terms of financial services, my view is if it's not quite dead, it's certainly mortally wounded. The amount of information that is now required to be out there, and which is public in many instances, means that where people had fiduciary structures, typically trusts underlying companies to hold their assets, whether they were personal assets, lifestyle assets, business assets, as we've heard from Maya earlier, they could have a degree of privacy by having a structure where their names did not appear. These things no longer exist. There are various reasons for that. The world has started off for obviously anti-money laundering purposes. This is where it first all started in the 1990s. So this is really about what is happening out there, and more importantly with this, now that privacy is being eroded to such a degree and so much information is required and there is so much information sharing for various reasons, it's a question of saying, what risks does that now bring to a client family? And there's a variety. So let us start by looking at what I call the current transparency roadmap. What is it that's out there which requires data to be shared with various organizations, various governmental agencies, and the like? I mentioned already anti-money laundering requirements, and I'll just touch there on the 4th and 5th EU AML directives. This really brought in amendments to the Financial Action Task Force, the FATF recommendations, which is a quasi body which really sets the ground rules for the anti-money laundering framework for jurisdictions across the world. So these directives were the EU's response to enhanced requirements. Some of the things that they did, as well as enhancing due diligence requirements generally for banks and the like, they brought in beneficial ownership registers for companies and beneficial ownership registers for trusts. In addition, actually, they also dragged in other providers of different services and brought them into under the remit of anti-money legislation. So typically, lawyers, accountants, casinos, high-value goods dealers, art dealers, and the like, all of which now have to collect know your customer information documentation in the same way as do banks. I've talked about the automatic exchange of information, and I'll talk a little bit more about that in detail. Backing that up are the OECD's mandatory disclosure rules, which are around avoiding reporting under the AEOI, as I call it, and the EU DAC 6, which incorporates not only that aspect, but also some elements of BEPS and aggressive tax avoidance planning. All of this results in reporting of individuals that use these schemes, which are by no means illegal. The fact of the matter is that they're designed there so that people, the tax authorities, know what types of schemes are out there, who's using them, and then can make a call as to whether they believe that's aggressive avoidance or not. So they can be perfectly legitimate, but still fall within the reporting frameworks. So what do I think? Having said that transparency is, or rather privacy, if not dead, is certainly mortally wounded, where are we going to go from here? It's moved a lot in the last 20 years. You know, from something which was relatively simple, banks just needing a copy of your passport and proof of address, now through to any number of people and different types of information being reported. Do I think this is going to go back? Do I think anything is going to change? Certainly out there are challenges to this. Tom Keating's, as you see there, made the point that we seem to be thinking of transparency as a means to an end, but it's something which has not been properly thought through. Fine for law enforcement agencies and the like to have access to information as and when they need it to support their investigations, but merely to make something transparent and visible to all does not achieve anything. That's a thought I would certainly agree with. Filippo Nocida, who's a partner with Miss Condorea, I've had the pleasure of sharing a platform on a number of occasions with Filippo, and he's launched legal challenges to both FATCA and CRS on the basis that they contradict data protection regulation and the right to privacy of people. Again, not something that I would disagree with at all. On the other hand, do I see any chance of these challenges winning the day? And quite frankly, no, I don't. I think even if they did, the goalposts would be moved and the rules would be changed such that CRS, FATCA and the like would be carved out of the GDPR. So these sorts of things are here and they're here to stay, in my view. And if anything, there will be further drives to make things even more transparent. So that is where we are, in my view. So how does this affect client families? Who is in the frame, as I put it? And in various cases, there's various people. The automatic exchange of information requires deemed account holders of trusts and companies to be reported as financial account holders. So you can see here for legal arrangements, trust foundations and the like, the trustees, settlors if they're still alive or partners of partnerships, a protector of a trust if there is one, beneficiaries that have a mandatory right to trust assets or income, discretionary beneficiaries if they receive a distribution from a trust, and creditors of a trust. For legal entities, companies and the like, the shareholders and creditors. And in certain instances, depending on the classification under the rules of that particular trust or company, it may also entail what they call their controlling persons, which essentially equates to beneficial owners in the anti-money laundering legislation. And again, it's generally the people that you see here who actually have no connection other than being say, a beneficiary of a trust which owns a holding company, which owns an operating company underneath, but they will be reported as being the deemed owners of that company in certain instances. So you can see it's quite right-ranging the number of people that are caught. And then you've got, in addition to that, these beneficial ownership registers of companies and trusts, which are a relatively new phenomenon. But essentially, again, the same sort of people will be deemed to be owners of the company. But here, and particularly in the EU, but other jurisdictions as well, this information is going to be publicly available. And again, you've got this issue of a chain of owners. So people who are unconnected directly with the entity as a shareholder, for example, will nevertheless appear on the register as an owner of that company. You've got financial institutions, banks and the like, who are asking, as we've already heard, for more and more information and more documentation. And all of this is being held and so forth. They're wanting more information about background, source of wealth, tracking back through many generations often requiring documentary evidence to support that. Mandatory disclosure rules that I've talked about. Here, this is really aimed at two things. It's avoiding CRS reporting, and specifically that's the OECD model. But the EU, under its DAC 6, also implemented the mandatory disclosure rules within that, but it also included schemes which might be aggressive tax avoidance schemes or BEPS avoidance and the like. The point here is that even if a scheme is perfectly legitimate, perfectly legal, no problem at all, it will still be potentially reportable, which means that, again, more information about individuals is flowing, in this case, as a user of a scheme that might be deemed to be avoidance of some kind. And that, I think, is not good for the individuals concerned. What is reported? Well, you can see up here, I won't run through it, but it's a lot of personal information and it's a lot of financial information, certainly in respect of automatic exchange of information. Here on this point, I would mention as well, the so-called deemed accounts that people have and the balances bear absolutely no relation necessarily to those individuals' tax liabilities, nor indeed what they're required to put on their tax returns. I gave you the example of a protector, but there are many others. There's also inherent duplication within the reporting because several institutions might share this so-called deemed account, trustees of a trust, bank accounts, custodians of investment portfolios, all of whom will have some reporting obligations, and it's all about the same asset. So this can be reported many times over. Avoidance we've talked about and what's reported there, but it's again the personal details about the so-called user of this scheme and also the information about the scheme itself. So we have a lot of information out there, and it's flowing, and some of it is going to be public. But additional to that, what happens if that information, even if it shouldn't be public, becomes public? There have been, as you know, many instances where such information has leaked into the public domain. You'll recall, no doubt, the Paradise and Panama papers. I'm sure everybody's familiar with those. Quite recently, last year, the Bulgarian tax authority was hacked. And as you can see, their 5 million residents' data ended up on the internet. The Cayman National Bank, this is not the central bank of the Cayman Islands, by the way, has Isle of Man operations, a bank and a trust company. That was hacked and data stolen and published. So not only is some information public, typically the registers, but you've got a situation where there's a strong possibility that information is going to leak out there anyway. So, and this has issues for client families, particularly ultra high net worth client families who are globally spread, generally speaking. So they need to understand the data is out there about them. It's mandatory. Their financial services providers are obligated to deliver this data. There is nothing that can be done about that. So they need to understand what is going to be public. They need to understand that some of it might become public even if it shouldn't. And therefore, they need to understand what are the risks that it brings. Now, these can be quite wide-ranging. I put a list up there of some of the fairly key ones that I believe exist. And they can range from just negative publicity. Typically, the Panama and Panama papers, the Paradise papers, the reporting there quite clearly had an aim to paint high net worth individuals in a negative light. In other words, that if they weren't actively evading tax, they certainly were making use of schemes which allow them to avoid tax, and therefore they were not paying their fair share of tax in the jurisdictions in which they live. That was basically the storyline. and it's sensationalist. It was inaccurate, but you know, as a colleague of mine once said, it doesn't matter if you're innocent and guilty. If it appears in the Financial Times, you're guilty. That's what people will read. You can go through other risks. Clearly, they can be, depending on where you live, they could be physical risks, so kidnapping, extortion, could be misappropriation of your assets. It could lead to family disputes because public information or information being public may allow one member of the family or one branch of the family to find out details about the assets and structures of another branch of the family, which maybe is not the overall family's intention that should happen. It could lead to undermining the aims and objectives of the family. They might want to use the wealth for different purposes, but knowledge gives individuals in the family the ability to say, well, I'd like my share, please. Also, of course, you might get inquiries from tax authorities, which unwarranted is perhaps the wrong word, but inquiries will arise which you have to deal with and ultimately don't result in any extra tax being gleaned or obtained by that tax authority. So from a family office perspective, from us as a service provider to our client families, what do we see as the responsibilities? Well, we need to make sure that whatever information is being reported about those families is at least accurate and it's about the right people. Within our organization, we not only provide family office governance services, but we also provide fiduciary services, asset management services, etc., etc. So a lot of the services that the family need, we do in-house, but not all family offices are like that, and many of them will use third-party service providers, trustees, for example, and the like. So you need to know, as the family office guiding that family, that the service providers that you use are actually doing what they should be doing, and it's all accurate and up to date. The client families, obviously, as I've already said, need to know what information is out there about them and who holds this information and what for. You need to draw attention to the risks that we've already talked about, and understand what are those risks cause that client family concern. Not all of them will necessarily, but you need to make sure that they have thought them through properly before they dismiss them as a risk that they're not concerned about. And then you need to help them with mitigation strategies for those risks that they are concerned about. So if they're worried about, for example, let's be extreme and say they fear kidnapping of their children, it's not something necessarily as an average family office you're going to be able to do. We certainly don't. But one of the strategies might be you employ a personal security firm. So as a family office, of course, you can't do that. But you certainly might help them to select one that would be suitable for their needs. When you form new structures, when you restructure, particularly, again, taking Maya's presentation earlier, when you're talking about restructuring businesses, you need to understand the effects of where data is going to flow as a result, whatever structure you end up. And it should be part of the structural planning. And you must always work with competent and trusted third parties where you need to, and you must make sure, and you do diligence on them, that they are trustworthy. Okay, that is really the end of our presentation. As I said, you can see we're an international family office, so represented in a number of jurisdictions. So we have a global client base. My particular role encompasses people from all these sorts of jurisdictions and elsewhere. I assist a number of families in what I've just talked about. So that's it from me at the moment. Happy to take questions.
Yes, thank you, Charlie. Thank you for your very informative presentation. There is one question from the audience, which is not concerning exactly what you were talking about, but it certainly falls into the sphere of your competence. One attendant is asking, will digital banks continue to thrive and be successful given increased KYC, AML, and fraud compliance regulations? I understand that by digital banking, they mean banks such as N26 and possibly Revolut, even though this is not a traditional bank at all. What is your stance on that, Charlie?
I think these sorts of operations are no different to other service providers in the sense of what they have to obtain. I think any financial services provider is faced with a tsunami of regulations coming down the road at them. What will happen, in my view, is those that are fleet of foot accept the regulations as they are, however daft some of them appear to be, however excessive some of them appear to be, and find a way to make it easy for them to implement and for their clients to be able to provide what is necessary with minimal pain for both. I don't think necessarily digital banks have a particular advantage because the rules that apply to them apply to everybody else. So they may thrive on the basis that they find a better way to do this digitally. At least they may well be ahead of the game as far as perhaps the traditional banks are concerned. But all of us have to find a way to make it simple for the client, a one-stop shop. As a typical example, with our client onboarding packs, they're quite extensive. We need to get the same information as a bank to the same level, and depending on the individual concerned and the perceived risk of that particular client in terms of where they live, how they made their money, whether they're a pet, all of that is driven by the regulations, and you cannot really wriggle out of that or reduce those requirements in any way. It's how you get all that information to the extent that it's necessary to do to satisfy your regulators, but that you make it as easy as possible to do for your client. That's the key, and one of those certainly is getting everything in one go. You need to ask the right questions, have the documentation prepared and ready. You need to be able to present it to them in one fell swoop. It's a bit onerous at the time, but once it's done, it's done. What is really, really difficult is if you then have to go back to the client again for some reason or another. So you need to know, for example, the core banks that you might deal with, what are their requirements? So do they differ from your own? And frequently they do. They're even more excessive sometimes. So you need to understand that, because if you know you're going to be opening a bank account, and you know that the banks are going to ask for this, that, and the other, you want to make sure you get it. So I think the question is a good one. I think they have an advantage to an extent because they're thinking that way, possibly, and they have the digital means to do that, whereas traditionally more people are still using forms and paper. So to that extent, it's better. But all financial services providers, I think, need to understand this and need to deal with it in the same way.
Okay, thank you. And I'll still try to use up the time that we have if we want to follow the schedule. We still have 5 minutes. So let me ask you, Charlie, how practically can you help your client families with the services that you offer? I'm thinking particularly about mitigating those risks that you mentioned.
Okay. Well, you really, the way I operate with this is really there is a 3-step process. The first step is to really understand what data about the client family is out there. So the first step really is to map that. So to do that, and typically for a family, an ultra high net worth family, it will be around the structures, the fiduciary structures that they have. You might not administer them all, but you need to understand the complete picture. Once you understand that, you will know from those structures who is likely to be reported under the automatic exchange of information, what KYC the banks are going to have, because all of this is standard stuff. But you need to know also, do they have relationships with people like art dealers, lawyers, accountants? But basically, because the rules, the AML rules and the AOI reporting rules are broadly the same, you can provide the clients with a map and say, these are the members of your family that will be reportable, or where information is being held by somebody. So you can give them the complete data footprint, as we call it. Step 2 is then to outline the risks that this brings to them as a family and whether they've considered this or not, and to discuss with them what is of concern, if anything. And as I say, the key thing is to make sure that they truly have thought through a risk before they can dismiss it. So, for example, if one takes kidnapping risk as the extreme one, you have a client family, the patriarch and matriarch, and many of them live in the UK, so they don't feel that there's necessarily a big kidnap risk. In the UK, it's generally a fairly law-abiding place. It's well policed. So they don't feel so threatened as if they were living in a jurisdiction such as Mexico, for example. That's fine and dandy. Okay, it's not a concern. But what if they have children of age somewhere between round about the mid-20s who have finished university, they have a good qualification behind them, but they want to go and do some charitable or do-good type work in Chad or the Congo or somewhere like this. Now, that then raises the possibility of the kidnapping risk, for example, as being something that they might need to consider and do something about. So that is what I mean by thinking through the risks to the fullest extent. But once you do that, you know, typically things like adverse negative publicity, you know, a lot of client families value their privacy, or value what was privacy. Now people are going to know about them, know about their assets, even if they were a fairly low profile family. So they might want to handle adverse publicity. So you then look at with them the steps that they might want to take and suggest strategies. So you could suggest strategies like, for example, you might employ some sort of PR type firm, so that if their data and their name gets out in the press, that there's a response ready to refute that, or to point out the good things that the family do in terms of charitable giving and the like. So the third stage in terms of working through the strategies and helping to implement them is very much a collegiate type effort with the family and their advisors. Generally not something that you're going to necessarily be able to help with yourself directly as the family office, other than being able to provide them or suggest or line up a beauty parade of suitable firms that can help. So that's really what we've done to date, and generally that's working quite well.
Okay, thank you again.